Good afternoon, everyone. Welcome back. We are now going to hear further opening statements from other core participants. The next person I'm going to invite to address us is Mr. Maxwell Scott QC, and I'm just going to check that, I think I can see him there, but check that he can hear me and see me. Good afternoon, Mr. Maxwell.
Yes,
you can
Good
hear.
afternoon. I can indeed.
Yes, good. Thank you very much. I think there's nothing more to be said other than to invite you to make the opening statement on behalf of the Council.
Mr. Chairman, panel members, I, together with Katie Sage and Bethany Condron, represent the Royal Borough of Kensington and Chelsea, instructed by DWF solicitors. As you know, we have submitted a 50-page written opening, which I anticipate the inquiry will make public later today. We also last week provided the inquiry with a document identifying some key changes made within the Council since the fire that are relevant to Module 3 issues. I do not intend in this oral statement to repeat all of the points made in our written opening. Rather, I wish to identify some themes which are likely to be important during Module 3. Before doing so, may I take this opportunity to say that the Council is truly sorry for the suffering and tragic loss of life caused by the Grenfell Tower fire. As the leader of the Council has previously stated, the Council could have and should have done more to stop it happening. The Council has adopted the Charter for Families Bereaved through Public Tragedy. It is committed to candour in its approach to this inquiry. There are 6 topics which I will address you on in this opening. The first is the Council's role in relation to Module 3 issues and the Council's monitoring of the TMO. About half of this opening will focus on this topic. The other topics will be expert evidence and guidance documents, the role of professional fire risk assessors in the years before the Grenfell fire, residents with vulnerabilities, flat entrance doors and self-closers, and finally, complaints. In our Phase 1 opening statement, we identified 10 principal ways in which the Council was involved with Grenfell Tower and its residents, both before and after the fire. In this module, we are concerned with 4 of them, which I can summarise in this way. The Council was the owner of Grenfell Tower. The residents were its tenants and leaseholders. The Council was their landlord. Both before and after the refurbishment, the Council worked closely with and monitored the TMO's performance. In Module 1, some of the Council's involvement was in areas in which the TMO had no involvement. Planning was an example of that. But the most important example was building control. You will recall that the Council identified and apologised for a number of failings in the way the Council's Building Control Service processed and considered the application for building control approval. In this module, we have identified a number of specific failings in the Council's monitoring of the TMO. They are set out in the Council's written opening statement, and I will mention some of them later in this oral statement. The Council apologises for its failings. Module 3 will be different to Module 1, because in Module 3, whenever you are considering the Council's involvement, you will also be considering the TMO's involvement in relation to the same issue. The TMO managed Grenfell Tower for the Council, and the Council paid it a management fee for doing so. As your expert, Dr. Lane, explains in her expert report, the effect of this management arrangement was that the TMO has consistently been the responsible person for Grenfell Tower since the fire safety order was introduced in 2006. TMO was the most significant of the responsible persons for Grenfell Tower due to the extent of its control over the premises. The TMO was responsible for the formulation, planning, implementation and operation of a fire risk management system for Grenfell Tower and the other properties that it managed on behalf of the Council. We appreciate that at the time, many residents saw the Council and the TMO as a single organisation, rather than two separate organisations. This is entirely understandable for a range of reasons. One of those reasons being the fact that the council worked closely with the TMO, but they were separate organisations, and that will need to be borne in mind when analysing the issues in this module. When considering the council's role in this module, you will very largely be considering how the council monitored what the TMO was doing on its behalf. But Dr. Lane is right when she says that she has found evidence of specific interventions made by the council regarding fire risk management. I suggest that the most important example of this was the discussions in 2016 and 2017 about a stock-wide programme to install self-closers on flat entrance doors. I will say more about that later. For the moment, I want to focus on the council's monitoring of the TMO. The council's legal relationship with the TMO was governed by the Modular Management Agreement. This was a long, complex document based on a template approved and issued by central government. It set out what was delegated to the TMO for it to manage on behalf of the council. It also had provisions on how the council would monitor the TMO's performance. This was supplemented by a TMO monitoring procedure guide agreed between the council and the TMO. These documents envisaged that the council would use a range of mechanisms to monitor the TMO's performance. In practice, as we explain in some detail in our written opening, the council did use a range of mechanisms to monitor the TMO's performance. I'm not going to go into all that detail now, but I will highlight some key points about the council's monitoring. The monitoring was done by officers and councillors, but as you would expect, more of it was done by officers. The council failed to follow some of the procedures set out in the MMA and TMO monitoring procedure guide. The most formal monitoring mechanism was the annual performance report in July and a mid-year report in November. These documents were formally reported to the cabinet member who held the housing portfolio, the TMO board, and the council's Housing and Property Scrutiny Committee. The reports drew together performance data, the outcomes of audits undertaken by the council's internal audit team, and other information. In the years before the fire, the overall assessment of the TMO in these reports was positive. Someone reading the reports would have been left with the impression that the TMO's performance did not give cause for concern. The reports always included a section on health and safety. Commentary in those sections tended to be positive, but it is right to acknowledge that the sections on health and safety were brief and tended not to cite evidence or empirical data in support of the points made in them. On reflection, the council considers that the number of council officers devoted to monitoring the TMO was insufficient, given the number of residents whose properties were managed by the TMO and the scale and importance of the task delegated to the TMO. The TMO reported key performance indicators to the council, but at no time did either of the two sets of KPIs reported to the council measure the TMO's fire safety performance. The council acknowledges that there were aspects of fire safety performance which could have been measured empirically and which could, therefore, have been made the subject of a KPI. The council should have told the TMO that it needed to have in place some KPIs to measure fire safety performance. It failed to do so. Mr. Chairman, you and others may be wondering why the council didn't monitor the TMO more than it did. I cannot point you to one single answer, but there are a number of matters of background which, taken together, help to provide an explanation. I will outline some of the key ones. The TMO was an independent organisation, owned by its members and accountable to its board. Residents elected to the board at all times made up a majority of the board members. From 2002 onwards, the TMO was an arm's length management organisation. When a TMO was set up in 1996, approximately 250 employees transferred from the council to the TMO. In 2017, the TMO employed over 200 people, including many in managerial positions. Those TMO managers were themselves monitoring the TMO's performance and reporting it to the TMO board. The council officers involved in monitoring the TMO were conscious that it was an independent organisation. Their work was not intended to duplicate the work of the TMO managers and board. The agreement between the council and the TMO did contain provisions that could be used to exert greater control over the TMO if it was underperforming. And the council had shown a willingness to use them when necessary. In 2008, the TMO agreed a deed of variation, which temporarily varied the TMO's obligations under the MMA, and an improvement plan was put in place. This temporary process ended in 2010. After that, there were a number of indications that, overall, the TMO had healthy governance arrangements and that its performance was improving. In 2013, the TMO Management Agreement Full Systems Audit and a 5-year review report both reached positive conclusions about the TMO. There was required to be a test of opinion of the residents every 5 years. The last one before the fire was in 2013. It was run by an external organisation, and the results were reported to the TMO board. They were informed that the number of residents who participated was the highest ever. 86% of those who voted for the TMO to continue managing their homes, and the results were better than those of neighbouring boroughs and had also improved. One of the TMO's aims was to increase its membership. In the period 2012 to 2016, it did so by almost 500 members per year. At the TMO's last annual general meeting before the fire, over 95% of those who voted were in favour of the TMO continuing to manage their homes. I'm moving now to my second topic, expert evidence and guidance documents. In this module, you have the benefit of expert evidence from two distinguished experts on fire risk assessment, Colin Todd and Barbara Lane. Mr. Todd has been probably the country's most well-known expert on fire risk assessment for many years. His advice has been sought by a range of governmental and non-governmental organisations, including the British Standards Institution, the Local Government Association, the Institution of Fire Engineers, the Fire Industry Association, and the Fire Service College. Dr. Lane is the Global Fire Safety Engineering Technical Lead at one of the world's leading engineering practices. She has proved herself to be a highly competent expert in the course of this inquiry. One of the themes running through this module will be the fact that Mr. Todd and Dr. Lane do not agree on all points. Similarly, the guidance documents that existed before the fire did not all give identical advice. Where there is disagreement between the experts, the panel will need to decide how best to resolve it. But there is a second aspect to this. Prior to the fire, there was one guidance document specifically designed for those managing purpose-built blocks of flats for local authorities. This guidance was published by the Local Government Association in 2011, following an extensive consultation exercise and input from the Department for Communities and Local Government and the Chief Fire Officers Association. It described itself as the more appropriate guide to use for purpose-built blocks of flats. In 2013, it was re-endorsed by DCLG after the inquest into the Lacknell House fire and was never revised or withdrawn before the Grenfell Tower fire. With the assistance of its assessors with social housing and local government expertise, the panel will need to consider the extent to which it would have been reasonable for those involved in the management of Grenfell Tower to focus on the LGA guide in preference to other guidance documents. Industry practice is likely to be a relevant consideration when analysing this issue. Industry practice is likely also to be relevant to your consideration of the fire risk assessments carried out on Grenfell Tower. In an ideal world, fire risk assessments would always be carried out by someone of the calibre of Mr. Todd or Dr. Lane. But this is not an ideal world, and it was never intended that the task of carrying out fire risk assessments be reserved to qualified fire safety engineers. For it to have been, the government would have needed to pass legislation regulating the sector. In fact, the sector was, and remains, completely unregulated. No qualifications are required by law. No training is required by law. There was, and is, no bar whatsoever to anyone seeking to go into business as a fire risk assessor. When one combines this absence of regulatory framework with what was going on in the sector at the time, one can see why Mr. Todd says the following about Carl Stokes, who carried out all the fire risk assessments on Grenfell Tower. His FRAs are amongst the most detailed of the many thousands of FRAs I've studied. Within the FRAs, there are many telltale indications that Mr. Stokes is competent to carry out a suitable and sufficient FRA in general, and more specifically, FRAs for high-rise blocks of flats, such as Grenfell Tower. In conclusion, in my opinion, Carl Stokes was competent to carry out FRAs for Grenfell Tower, taking into account his training, skills and qualifications in the practice of fire safety and the FRAs that he documented. There can be no doubt that at the time, the TMO genuinely believed that Mr. Stokes was a competent fire risk assessor, providing it with a professional service. And that presumably explains why the TMO sought his advice on such a wide range of issues. Because Mr. Stokes didn't just do fire risk assessments for the TMO, he also advised on issues that applied generally to the properties managed by the TMO and on issues specific to Grenfell Tower. Mr. Stokes' fire risk assessments and advice to the TMO will be central to many of the issues to be considered in this module. The panel will need to consider whether he was a competent fire risk assessor and whether his fire risk assessments for Grenfell Tower were suitable and sufficient. But it will also need to consider whether anyone at the time had reason to doubt his competence or the adequacy of his fire risk assessments, and if so, who? I now turn to the topic of residents with vulnerabilities in the event of fire. This is not a phrase used in the fire safety order, but it is a helpful phrase used by Dr. Lane to cover adults with cognitive impairment, adults with sensory impairment, adults with mobility impairment, and children. This is an important issue because the evidence suggests that a higher proportion of adult residents with such vulnerabilities died in the fire. Here, the different approaches recommended in the different guidance documents is particularly stark. Most of the guidance documents advised that specific measures be taken to protect, for example, disabled residents. But in contrast, the guidance in the LGA guide, which was current at the time of the fire, stated that it is reasonable to expect that the occupants of a general needs block of flats will reflect the diverse range of physical and mental capabilities of the general population as a whole. It should be determined as to whether the number of disabled people is likely to be different from a typical general needs block of flats. It is usually unrealistic to expect landlords and other responsible persons to have in place special arrangements, such as personal emergency evacuation plans. The position at Grenfell Tower was that no resident had a personal emergency evacuation plan, and none of the fire safety advice from the TMO to residents contained advice tailored to the needs of persons who would be vulnerable in the event of fire. Here again, with the assistance of its assessors, the panel will need to consider the extent to which it would have been reasonable for those involved in the management of Grenfell Tower to focus on the advice in the LGA guide in preference to that given in other guidance documents. They will also be able to assist you with whether the occupancy profile of Grenfell Tower was different from other general needs blocks of flats. I now turn to the topic of flat entrance doors and self-closers. Phase 1 established that a major route for the spread of toxic smoke within Grenfell Tower was from individual flats through flat entrance doors into communal areas. At the time of the fire, there were 120 flats in the tower located on floors 4 to 23. The flat entrance doors to 106 of those flats had been replaced in 2011. There are three main reasons why those comparatively new doors did not prevent the spread of smoke. The first reason is that some of them were open rather than shut on the night of the fire because they did not have a working self-closing device. All of them had been fitted with self-closers when they were installed, but for various reasons, some of them were no longer working or no longer present some 6 years later. Not all of the council's tower blocks were fitted with self-closers in 2011. One of those that was not was Adair Tower, where fire broke out in October 2015. After that fire, self-closers were installed in Adair, and consideration was given to introducing a self-closer programme through all of the properties managed by the TMO. The council acknowledges that there should have been such a programme in place before the Grenfell Tower fire. In fact, there had been a decision in principle to implement a programme. It had not begun to be rolled out. The TMO and the council were both involved in the decision-making process. Where responsibility lies for the delay in implementation is something that can only be decided once you have heard from the relevant witnesses from the TMO and the council. The second reason why the doors did not prevent the spread of smoke is that testing done since the fire has established that many of the doors were not compliant and did not resist fire and smoke for 30 minutes, as they should have done under the contract between the TMO and its supplier, Mance Master Door. The purchase of the doors was a sizable procurement exercise, and the TMO were assisted in it by the London Housing Consortium and Mr. Stokes. Sadly, the problems with the fire performance of the doors were not limited to one batch or even one manufacturer. Subsequent events have revealed that these problems occurred on a national scale and were so serious and widespread that, in 2018, they resulted in major disruption to the supply of composite fire doors to the UK market. The third reason why the doors did not prevent the spread of smoke should not be overlooked. It is this: the doors were never intended to withstand fire and smoke indefinitely, nor were they required by law to do so. My final topic is complaints. It is clear that a significant number of residents of Grenfell Tower felt very strongly that it was not being managed as well as it could and should have been. Some of them were frustrated by how they were treated by the TMO, Ryden, and the council. Some of them complained. Some of those who complained were dissatisfied with how their complaints were handled and did not feel respected. Matters which led to high volumes of frustration and complaints included the power surges in 2013, issues which arose during the refurbishment, lifts breaking down, and the gas riser works in 2016 and 2017. It is entirely understandable that residents were frustrated by these matters and complained about them. We say something about each of those individual matters in our written opening. Today, I'm going to concentrate on the systems for addressing complaints. The TMO and the council had separate complaint systems. Each organisation's complaint system had 3 formal stages. The 2 complaint systems were not interlinked. There was no right of appeal from the TMO complaint system to the council's complaint system. The council's monitoring of complaints submitted by residents to the TMO was limited. For example, the TMO only formally reported a complaints KPI to the council for 2 years, ending in 2015. In practice, Many Grenfell Tower related complaints were submitted in emails sent to recipients within both the TMO and the Council. What then tended to happen was that the complaints were referred back to the TMO to address or left to the TMO to address. The TMO was better placed to address matters of detail raised in complaints about services managed by the TMO. We therefore consider that, in general, this approach made sense, but it also had a weakness. The weakness was that it increased the risk of patterns in complaints about the TMO or its services being missed by the Council in its monitoring of the TMO. This brings me to the end of the themes in Module 3 that I wish to address you on today. As you are aware, we cover a wider range of topics in our written opening statement and also analyse the evidence in more detail there. That evidence will be added to by the evidence of witnesses due to be called in April, May, June and July. In our closing statement, we will take account of that evidence and set out the Council's position in further detail and in accordance with the Council's commitment to candour. Thank you. That concludes my opening statement.
Well, thank you very much indeed, Mr. Maxwell Scott. At this point, we would expect to hear from Mr. Agaros on behalf of the Tenant Management Organisation. He was due to appear at 3:15, and I don't know whether he's actually...
I'm here, sir.
Oh, Mr. Agaros, good afternoon.
Good afternoon.
You are here. Is it convenient to you to make a statement at this point?
Yes, if we may, please, sir.
We would normally have a break sometime during the afternoon. You're currently scheduled to have an hour if you want to use it. Would you like to see how you're going round about 3:15? And if you reach a point, broadly speaking, somewhere around between 3:15 and 3:30, when it would be convenient to take a break, perhaps you could let me know.
Yes, thank you very much, sir.
Right, well, thank you very much. You can obviously hear me and see me. And,
I can see you all.
And good. And it just remains, therefore, for me to invite you to make your statement.
So, Mr. Chairman, panel members, we too have submitted a near 50-page written opening statement. And these oral submissions represent an abbreviated version of that statement, and they develop themes which are set out there. And so we invite the inquiry to refer to those written submissions when considering the detail of any oral submissions made here. So may I say at the outset that the TMO and all that worked for it acknowledge the immense tragedy of the Grenfell Tower fire, and nothing in these submissions is intended to diminish or detract from that tragedy. All those who give evidence on behalf of TMO, and there will be many of them in Module 3, sir, continue to express their profound sympathies and condolences to the bereaved survivors and residents. So topic 1 of Module 3 is primarily concerned with the TMO systems for communication with residents, consultation concerning the refurbishment, residents' complaints regarding fire safety risks, doors and the quality of workmanship during the refurbishment, and the response and degree of engagement, I think as you put it, of the TMO and RBKC to those complaints. So you'll hear first from former residents of Grenfell Tower, and then from witnesses from the TMO and RBKC at varying levels of seniority regarding the systems, policies and procedures each body had implemented to deal with residents' complaints and their response to those complaints, as well as the management of the building. So you're also going to hear evidence about the governance arrangements between RBKC and the TMO, and in particular how they worked during the refurbishment. And to that end, you will hear from senior representatives from TMO and RBKC. So we acknowledge that when considering the issue of complaints and concerns, the inquiry's primary focus will be on matters causally connected with the fire, but the inquiry will also consider the way in which complaints more broadly were managed. And so this being the case, the TMO intends to briefly address some of the wider issues touching on that topic here. Forgive me. At the outset, and it's right that we say this, sir, the TMO acknowledges that the relationship with some residents was sometimes strained and difficult, both before and during the refurbishment. And we have no doubt that you will scrutinise the reasons for this. However, so this is not to say that all residents were always at odds with the TMO, and the inquiry may wish to consider whether views expressed by some more vociferous residents were truly representative of the views of a majority of residents. But so can we say in a nutshell that the TMO doesn't accept that it ever adopted a dismissive attitude towards residents or indeed to their complaints and concerns? So we suggest that when you look at the nature of the relationship between TMO and the residents during the relevant period, that the inquiry should have particular regard to the following three factors. So first, there had been vehement opposition from some residents at Grenfell Tower to the CALC project, and forgive the abbreviation, but it's for the sake of time, from its very inception, and strong criticism of RBKC in particular. And much of this criticism was voiced in the Grenfell Action Group blog, which I'm going to refer to as the GAG blogs going on. So the inquiry may consider whether this soured the relationship between some tenants and the TMO and RBKC, but also indeed whether the strong opposition was representative of the Lancaster West community as a whole, given that the CALC project was to build a much needed school and leisure facilities for children in the borough. Second, the TMO finally took over in 2014 from the Estate Management Board, referred to as the EMB, for the Lancaster West estate. The EMB was a tenant-led organisation separate to and predating the TMO, which was first registered in 1993. There came a point when the EMB was not functioning well, and there was a strongly held view that its members were unaware of what was expected of them. Although it's right to say that residents voted at one point to retain the EMB, concerns remained about its performance, and RBKC worked on an improvement plan, a step which was prescribed by the MMA. This failed to result in progress, and the RBKC eventually terminated the contractual relationship with EMB in 2014. Despite a widespread perception of mismanagement, and so there are various emails which relate to this. Some residents thought it had been shut down, and this is a quote, in an underhand and duplicitous manner by RBKC. And so, of course, it's a matter for the inquiry, but we would submit that this probably created a breakdown in trust between the TMO, RBKC, and some residents, and impaired TMO achieving a good relationship with some tenants going forward. So third, when considering the nature and volume of complaints made by residents during the refurbishment, it should be kept in mind that for residents continuing to live in situ when major works were occurring both inside and outside their flats can only have been extremely difficult. The construction work was intrusive and noisy, and one lift was often unavailable to residents because it was being used by builders. And so against this background, it's possibly unsurprising that there was an increased number of complaints and expressions of dissatisfaction from residents. Indeed, consideration was given to the possibility of rehousing residents during the refurbishment, but this was not thought practicable or desirable. Indeed, some residents had concerns that if they left the area, they would be rehoused in an unfamiliar location and would not be able to return. While such concerns were certainly baseless, they are indicative of the level of mistrust that existed between some residents and the TMO RBKC. So we have an eye to the evidence that you will be hearing in this module, and one of the parts of evidence will be in relation to fire-related complaints, will be the contents of the Grenfell Action Group blog dated the 20th of November 2016. Just to say a couple of things about the blog. In fact, the language often used in the blog was indicative of the levels of mistrust that had built up in the minds of some residents towards the TMO. What we on behalf of the TMO submit is that the inquiry should be cautious about the contents of the GAG blog because it contained a highly personalised narrative, including a number of personal attacks on TMO and RBKC employees, and because indeed The authors never identify themselves. The blog often uses the word we in connection with the residents of Grenfell Tower, and so far as the TMO is concerned, it appeared to be the work of, at most, a handful of authors. So we summarize one part of the blog, and the November blog said, and this is a quote, and we've abbreviated the quote, and I hope not unfairly so. It said that the TMO was an irresponsible mini-mafia and only an incident that results in serious loss of life to KCTMO residents will allow the external scrutiny to occur that will shine a light on the practices that characterize the malign governance of this non-functioning organization. So what we say about that is this, is that despite the appearance of prophecy, and we acknowledge that, the writers were certainly not predicting a cladding fire of the type that occurred on the 14th of June 2017. So far as the TMO is aware, no witness or organisation connected with this inquiry predicted such a fire at Grenfell Tower, despite the fact that similar cladding fires had apparently occurred abroad, and about which you have heard evidence in phase 1. So ultimately, it's a matter for you, but we would submit that the evidence that you've heard in previous modules bears out that the fire was not caused by the malign governance of a non-functioning organisation, i.e. referable to TMO. Rather, it arose from the widespread and deep-rooted blindness within the private and public sector to the inherent dangers of materials regularly used in the building industry, or even worse, by deception for commercial gain on the part of those companies that marketed and supplied cladding and insulation. So the evidence the inquiry has heard in Module 2 thus far was, it submitted, truly shocking, and shows that even those with responsibility for safety certification did not uncover the combustible nature of the products used in the refurbishment. So a measure of the extent of the blindness, as I've referred to it, is the fact that some 2,000 buildings across the UK had been clad in and insulated with similarly combustible materials. Although the fire happened at Grenfell Tower, it could as easily have happened at another building clad in combustible materials. And so it's no doubt for this reason, among others, that fire marshals maintain vigils at numerous buildings even to this day. So the debate about how to solve this systemic and far-reaching problem continues even now between the government, the construction industry, and building managers and their tenants, including who will bear the costs for removal and replacement of cladding. So when considering the role of the TMO, we invite the inquiry and you, the panel members, to bear this in mind, that the TMO was an organisation staffed by non-construction professionals with a background in social housing. This was a design and build contract, and the TMO relied on various specialists and industry professionals throughout the refurbishment project. And its reliance on professional advisors represented the norm for contract procurement and capital works within the public sector. So while, and if I may say rightly, as you have put it, and I hope I quote you correctly, that the TMO was an educated client, it operated only with the reasonable foresight of a social housing manager, and in not foreseeing such a terrible tragedy, it was no different to hundreds of other organisations across the UK. The question must be whether the TMO is to be judged differently to organisations in a similar position. So Dr. Lane particularly criticises the TMO for not uncovering the risk the refurbishment posed following warnings arising from two fires, the Lacknall House fire in 2009 and the Shepherd's Court fire in 2016, and the warning letter from LF-EPA as a result of the Shepherd's Court fire in April 2017. So the TMO invites the inquiry to consider whether it alone should have been expected to see through the deceptions practiced by the manufacturers of the cladding and insulation, especially when certifying bodies such as the BRE and BBA approved their suitability for use in construction and/or provided misleading certificates which inspired trust in materials used on the tower. So hundreds of other building owners or managing organisations did not untangle this subterfuge, even when, like the TMO, they were advised by teams of professionals. So I'm going to deal now with the issue of resident engagement. And may we say this, that the TMO put considerable effort and resources into resident engagement, which we define as the drive to ensure residents were involved in decisions surrounding the management of their homes. The TMO was and was designed to be a resident-led organisation, and its constitution made it a requirement that the board consisted of a majority of residents, including the chair. From the time that Robert Black was appointed chief executive in 2009, the TMO sought to stimulate meaningful resident engagement, recognising that it had fallen to a low level, especially following the demise of the EMB in 2014. Initially, a door-knocking exercise was carried out across all properties in the TMO estate to understand what residents' main issue and concerns were. Following this, the TMO sought to increase resident membership in a number of ways, for example, by holding roadshows, annual conferences, the Senior Citizens Annual Party, the Youth Engagement Project, and the TMO Live Up Your Game projects. It also promoted the creation of residents' associations, which numbered something like 53 across the borough, with 10 alone set up in 2015, 2016. So all of this work was done by a dedicated resident engagement team, which included a resident engagement manager. So we appreciate that reference to figures that demonstrate levels of resident engagement may not be helpful without context, which we're not going to provide fully here. It's in the written submissions, but the drive to increase resident engagement was certainly successful. An example is the increase in turnout for the TMO board member elections, as well as increased participation in the AGM. The 2016 AGM, 96% of the over 1,200 people who voted were in favour of TMO continuing to manage their properties. Possibly the most telling measure of resident engagement, and indeed of resident approval, was the test of opinion, which was carried out every 5 years, where TMO members were asked if they wanted the TMO to continue to manage their homes. The most recent test of opinion before the fire involved an increase in participation of 122%, and there was an overwhelming vote in favour of the TMO continuing in its management role. So in very real terms, if it had been the residents' wish, the TMO could almost literally have been voted out of existence or other management arrangements put in place. So resident engagement was monitored by RBKC, and it received a substantial assurance result in the minutes of the HRA performance meeting in February 2017. Turning now to the question of resident consultation for the refurbishment. So we anticipate you will hear that the TMO sought actively to consult with residents concerning the refurbishment from the earliest stages. This included giving residents a choice about how they would like to be consulted. Consultation on design proposals for the refurbishment took place in 2012 and 2013 in particular, in many different ways, including, we list these here, so they're listed in the submissions, through meetings in both the daytime and the evening to accommodate as many residents as possible, newsletters which invited residents to roadshows and consultations, and questionnaires where residents were asked about a number of matters, including their priorities for windows, i.e. whether they should be self-cleaning, and options for the operation of the windows, i.e. pivot, reversible, sliding, or tilt and turn, whether Grenfell Tower would benefit from thermal insulation cladding. And so there was a high yes vote for this, but no clear opinion was expressed about the colour or type of cladding, whether homes would benefit from new individual boilers, which could be controlled by each flat individually. And again, there was a high yes vote for this. Residents were also kept up to date via newsletters. For example, there were 3 in 2013, which advised of any changes to the plans submitted and reported on the results of surveys, etc. And so we've referred to those in detail in the written submissions. And in addition to the above, Rydens, the principal contractor, hosted coffee mornings, and arranged home visits from their resident liaison officer, Linda Prentice. So throughout its consultation process, the TMO sought to obtain as many resident views as possible on the refurbishment. And moreover, as an example of how the TMO listened to resident views, it did adapt the project after listening to residents. For example, it changed the design of the windows when it became apparent that the initial proposals would result in more intrusive work being done internally to flats. It recognised and engaged with a new residents' compact when it was suggested that residents' concerns were not being heard properly by the existing Lancaster West Residents Association. And it eventually moved the HIU after residents challenged TMO about its revised position. And we'll go into that in a little bit more detail later. So dealing now with complaints and service inquiries, the TMO certainly had in place systems for dealing with residents' concerns and complaints, including those concerned with the refurbishment. However, and we acknowledge this, the content of many of the statements from residents, witnesses, and the TMO evidence may be difficult for the inquiry always to reconcile. The picture painted in those statements is sometimes very different. And of course, that will be a matter for the inquiry to consider carefully in Module 3. However, complaints handling was always a priority for the TMO, and its performance was monitored both internally and externally. Internally by the operations team, the senior management team, the executive team and the board, and externally by RBKC. The TMO's complaints policy required it to apply the Housing Ombudsman principles for effective complaint handling. The portfolio was overseen on a day-to-day basis by the TMO's policy and improvement manager, and there was a dedicated complaints manager and 2 complaints officers. The complaints team had monthly meetings where all issues were discussed, and a quarterly report on complaints was prepared containing KPIs and statistics. The complaints policy distinguished between a complaint and an inquiry. An inquiry was defined as, and I hope the quote is accurate, a first-time request for information, advice, or for an action to be undertaken, e.g. estate cleaning not undertaken, estate lighting not working, or a repair request. On a practical level, an inquiry would be passed on by the staff member receiving it to either the customer service centre or directly to the relevant team for action. The intention of the TMO was always to resolve inquiries as soon as possible without them escalating into formal complaints. And so, of course, we've seen some of the submissions made by the BSRs, but we would say this wasn't in an attempt to bypass or avoid formal complaints, but because informal resolution was always preferable. By contrast, a complaint was defined as an expression of dissatisfaction about a KCTMO service or a service provided by a KCTMO contractor, not resolved immediately to the customer's satisfaction about the level, quality, or nature of a service which the customer feels should have been provided. The TMO publicised the complaints procedure widely to residents on its website at roadshows, in the Link magazine, and through leaflets and posters in the housing offices. And against this background, so we invite the inquiry to consider whether some of the BSR's contention, i.e. that the complaints policy was not widely known or understood, is correct. Residents with concerns or complaints could contact the TMO by a number of means, including emailing a dedicated complaints email address, calling the customer service centre, or visiting their local housing office. Complaints and inquiries were logged and progressed through the W2 system initially, and from 2016 through the CRM system. A complaint would first be assigned to the complaints team and then reassigned to the relevant TMO team, for example, Repairs Direct. But the complaints team would always monitor outstanding complaints to ensure compliance, including time limits, etc., and would use an interactive complaints dashboard to monitor this. The complaints policy set out a three-stage process. Stage one involved an investigation by the manager of the relevant service area. And if a resident was not happy with the outcome of the investigation, they could escalate their complaint to stage two. Stage two involved an investigation by the head of service. Residents who were still dissatisfied at stage two could request a stage three review, which was the final stage of the procedure and involved a formal panel meeting comprising of an independent board member or a council appointed board member, a resident board member and an executive director. A board member chaired the panel, and in the later years, the complainant could attend the panel in person. If dissatisfied with the outcome of the stage three review, the resident could appeal to the Housing Ombudsman. Complaints performance was monitored using a set of KPIs and was reported to the executive team and the operations committee. The complaints and the procedure was subject to an internal audit by the RBKC team, and RBKC maintained independent oversight of complaints. So can we touch on now a few complaints arising from the refurbishment, some particular complaints, but make this point at the outset that it's important to note that the primary mechanism for raising concerns during the refurbishment was through Ryden, who had a permanent resident liaison officer, RLO, based in the tower to deal with any day-to-day issues. The RLO details, including when they were available, were communicated in each newsletter. There was also a Ryden's email address via which residents could express their written concerns to Ryden. Claire Williams, from whom you've heard and from whom you will hear from the TMO, also liaised closely with Ryden's RLO, both during and after the works, and always sought to ensure that residents' concerns and requests for repairs were dealt with. The TMO and Ryden also held regular liaison meetings to discuss concerns and housing management issues impacting upon residents. So dealing with formal complaints, there were 7 formal complaints from 4 separate residents during the period of the refurbishment. Of these 7 complaints, 4 were submitted by the same resident, 4 were not upheld, 2 were upheld, and 1 was partially upheld. So may we say straight away that we recognise that this simple figure, this simple number, does not fully capture the level of concern expressed by residents about the refurbishment, and their concerns were often conveyed in different ways. But what we do say, sir, is that it demonstrates there was a system in place which residents were able to use, and indeed the outcome was not always in the TMO's favour. We deal now with the history of a particular formal complaint made to TMO. And so it's this: in December 2015, Edward Defan made a complaint relating to the refurbishment works. It was heard at stage 1 by Peter Madison and not upheld. Mr. Defan escalated his complaint to stage 2, where it was considered by Mr. Madison's line manager, Sasha Jevons, the director of operations. She concluded the handling of the matters Mr. Defan was complaining about had been appropriate and did not uphold the complaint. Mr. Defan escalated his complaint to stage 3, and it was heard by a stage 3 panel in February 2016, and there was a unanimous decision not to uphold it. As was his right, Mr. Defan took his complaint to the Independent Housing Ombudsman, and the Ombudsman also concluded that there had been no maladministration and no service failure. So you have the Ombudsman's report, and it's a long document, but in summary, the conclusion was the TMO had acted reasonably, rearranging commencement dates for works, and there had been no maladministration. So turning now to consideration of complaints that didn't go through the complaints procedure, there was, as I've said earlier, an existing residents' association for Grenfell Tower and the Lancaster West estate, which had been established in 2015. Some residents were unhappy about the way in which it operated and wished to start a separate organisation, and as a result, the Residents' Compact came into existence in 2015. At a residents' compact meeting in June 2015, it was suggested by members that the TMO, and again, so this is a quote, had harassed, lied, and intimidated residents over the duration of the works. At the meeting, the TMO gave a commitment that any specific allegations would be investigated in accordance with the complaints procedure and appropriate action taken to resolve the matter. A petition signed by 51 residents was presented to the joint TMO-RBKC meeting on the 2nd of December 2015, asking the chairman of the Housing and Property Scrutiny Committee to undertake, and again we quote, sir, urgent scrutiny of the TMO and Ryden's management of the refurbishment project currently underway at Grenfell Tower. Our day-to-day concerns are belittled and sidelined. While we recognise that once completed, the tower will at long last be fit for the 21st century, during this process we have had to endure living conditions that at the time have been intolerable. And so, of course, we accept at the beginning of the submissions that the conditions for the residents must have been extremely difficult, and nobody is doubting that. Following receipt of the petition, the TMO undertook a door-knocking exercise and spoke to 77 of the 120 households in Grenfell Tower. By contrast to the petition, the door-knocking exercise disclosed a high level of satisfaction concerning the refurbishment, and no resident raised any issues relating to bullying or harassment. Mr. Defan made a speech to the Housing and Property Scrutiny Committee on the 6th of January 2016, where he raised similar concerns to those in the petition. And in the light of this, the TMO convened a formal inquiry and review to examine the Grenfell project overall while the works were still occurring. The panel chosen to conduct the inquiry was chosen to be representative and unbiased and included a number of resident board members. The review had wide terms of reference and examined issues such as resident consultation and engagement, the position of the HIU in the hallways, allegations of threats, lies and intimidation, response to complaints, quality of work and site management and compensations. And there were presentations and a tour of Grenfell Tower. The group recognised that there were significant challenges with the project and acknowledged that residents would have experienced inconvenience due to the nature of the construction. However, it concluded that there had been comprehensive consultation with residents, including over HIUs, and the TMO had responded adequately to complaints. And it concluded that controls were sufficient to manage a construction project of this size and nature. But it's right to say, sir, and they're set out in detail, the group did make certain recommendations regarding the need for changes for future projects, an example being the recording of names of residents who attended consultation meetings. So dealing lastly with one other matter in relation to complaints, and if I may, I'll ask for a break because I think it follows naturally as according to where we are. These are complaints which were made by and on behalf of the Grenfell Tower Leaseholders Association, which we abbreviate to GTLA. An example of a complaint raised by the GTLA is for Mr. Tunde Awaderu, who in April 2017 sent an email to TMO and RBKC requesting an independent expert investigate the gas works at Grenfell Tower. The background to this is the tower's gas supply was historically introduced by 4 risers, one of which ruptured and had to be replaced. This was done by the statutory gas utility company Trio, pursuant to its statutory powers. While consulted, neither TMO nor RBKC had final say over how, when and where the work was done. And residents, as so you'll hear, became understandably concerned about the work, particularly that the new gas pipe was left exposed in the stairway. In response to the complaint, the TMO instructed Carl Stokes to visit the tower and inspect the newly installed gas riser and laterals. He visited the tower in January 17 and published a report which was provided to Trio with 8 recommendations relating to fire stopping and gas safety. Trio in turn provided an assurance to the TMO that the newly installed lateral pipe work would be boxed in for ventilation purposes and holes sealed where they were not needed for ventilation. And so this was work which was ongoing at the time of the fire. And we have no doubt that the inquiry will look at this issue extremely carefully. So the inquiry will also be hearing from the resident David Collins, and it's accepted and recognised that Mr. Collins also raised a number of concerns and complaints with TMO at different times during the refurbishment on behalf of himself and other residents. Mr. Collins stated after the fire, i.e. in his statement, that a lack of engagement, and again we quote so hopefully accurately, lack of engagement with the TMO and their agents meant that residents never learnt in detail about the cladding materials or other aspects of the project which were a risk to residents' safety and well-being. He predicted, I said this before, the fire, a bad outcome for the TMO if resident engagement was not more effective and monitored externally. So the TMO accepts the inquiry will give careful consideration of the complaints made by Mr. Collins and will examine whether they were dealt with appropriately. But we would say this, in relation to any complaint raised by him regarding consultation over the cladding, the residents were consulted about the cladding, albeit not about its fire retardant properties, as it was legitimately assumed by the TMO that its professional advisors had given proper consideration to compliance with safety standards. Following the works, residents were spoken to directly to ascertain what defects remained outstanding by Ryden's RLO and by Claire Williams. The defects in the main said to be outstanding, windows and kitchen fans, are closely consistent with the defects list compiled by Ryden. And so you know that the defects period expired on the 4th of July 2017, i.e. after the fire. So, of course, it's a matter for the inquiry, and we acknowledge the strength of the evidence from the BSRs, but the TMO submits them overall terms. Complaints and concerns were dealt with and responded to in an appropriate and generally timely manner. In addition to the complaints process, there was scrutiny by a panel of board members and oversight by RBKC. And the fact that some complaints which were formally escalated up were eventually upheld still illustrates the point that this was a process and system in place which was transparent and effective to a degree at least. So I'm moving on now to the topics in 2 and 3, and I'm conscious of having been going for about half an hour. So if this would be suitable for you and the panel members to have a break, it would be suitable for me.
Good, thank you very much. Well, you've got a little bit further to go, haven't you, anyway?
I have a bit further. So can I just say, for all those who are listening, I would anticipate the remainder of my oral submissions will be about half an hour.
Yes. Well, I think it probably would be convenient to have a break at this point. And if we came back at 25 to 4, that would still mean we'd finish roughly within time.
Thank you very much.
So, thank you very much. We'll break now. We'll resume at 25 to 4 then, please.
Thank you.
Thank you. Welcome back, everyone. I'm going to invite Mr. Agros to continue his opening statement on the
So
tenant.
thank you very much. Dealing now with topics 2 and 3. Topic 2 will consider the TMO and RBK's obligations under the Regulatory Reform Fire Safety Order 2005 and their compliance with those obligations. Topic 3 will consider the active and passive fire safety measures inside Grenfell Tower and the management and maintenance of the building. As it's likely that the inquiry will invite witnesses giving evidence in topics 2 and 3 to address propositions and opinions expressed by Dr. Lane in her recent reports, for the purposes of this opening, the TMO will focus on some of her key findings, as well as giving due regard to the reports prepared by other experts commissioned by the inquiry, such as Colin Todd and Roger Howkins. Excuse me. We make the following general observations about Dr. Lane's Phase 2 report. It's only recently been served and it's long, dense and complex. Dr. Lane, along with numerous assistants, has carried out a full forensic audit of the TMO's fire risk assessments and action plans, measuring its performance against legislation, statutory instruments and sector guidance. Her report has been produced with the benefit of extensive time, resources, and importantly, with the full benefit of hindsight. Separately, her report has been served piecemeal within the last month without its conclusion chapter, leaving the TMO with, we respectfully submit, limited time to address it fully in this opening statement. And so this has been compounded by the fact that TMO is no longer an active organisation. And therefore, to the extent necessary, the TMO may address further issues in its closing statement for modules 1, 2 and 3. So when the inquiry examines what TMO employees did and did not do in relation to Module 3 topics, it should bear in mind that when devising its fire strategy, no individual at TMO, nor apparently any of its professional advisors, had an inkling the tower would ever be engulfed entirely in flames from the outside, which then rapidly infiltrated back into each flat. And finally, as you have observed, sir, completely overwhelmed the active and passive fire measures, whatever their state of repair. Rather, when devising and maintaining the active and passive fire measures, TMO's expectation was that at worst, there would be a fire in one flat, which would cause the occupant of that flat to leave, but that all other residents would be protected in their own flats by compartmentation without the need for simultaneous building-wide evacuation. The submitted inquiry should assess the TMO and its employees' actions in the light of what was reasonably foreseeable to them at the time, and not with the bright illumination of hindsight. So next, the TMO also considers that Dr. Lane is sometimes over harsh in her criticisms of Janice Ray in particular. This may be because she does not always accurately describe Janice Ray's role at the TMO and sometimes appears to fundamentally misunderstand it. Janice Ray was employed as the Health and Safety Facilities Manager, which was an occupational health and safety role. Her remit was not just Grenfell Tower, but the whole of the property portfolio managed by TMO, which included 19 tower blocks and over 10,000 properties. One of the things said by Dr. Lane is Janice Ray had unique responsibility for ensuring active and passive fire measures were properly maintained at the tower, when in fact a large part of this fell to the contracts management team. And so in this regard, and of course it's a matter for you, we note the inquiry is not proposing to hear live evidence from an individual from within the contracts management team, and we respectfully invite you to consider doing so. The TMO submits that Janice Ray was a hard-working and dedicated health and safety professional who acted in an organised and efficient manner, always seeking to gain full visibility of the health, safety and fire issues occurring within the TMO, and then to address them expeditiously with the resources available to her and her team. Further, she was not and never purported to be a specialist in fire safety or herself a fire risk assessor. And while, of course, she was involved in producing the fire safety strategy, this was in consultation with other professionals. And when it came to the production of the fire risk assessments, it was necessary for her and the TMO to engage and rely on professional fire risk assessors such as Salvus Consulting Limited and Carl Stokes Associated Limited. Dr. Lane also makes numerous criticisms of Carl Stokes, and it's for the inquiry to decide whether these are justified or not. But the TMO observes that many of her criticisms run contrary to the views of Colin Todd, who is an expert in fire risk assessment, which Dr. Lane, although eminent, is not. Indeed, Mr. Todd says of Carl Stokes, were Mr. Stokes to apply for registration by the IFE on their register of fire risk assessors, I would have no hesitation on the basis of his training, experience, and examination of his FRAs in recommending him. So further, we submit that when criticising the TMO, Dr. Lane does not always give proper account to the practical realities for those managing social housing within budgetary constraints in the public sector. This is not, of course, to say that any decision taken by a TMO put costs before safety, but that TMO never had the means to develop its fire safety strategy in all of the ways Dr. Lane suggests. Indeed, sir, and against a matter for you, we consider it as unfortunate that the inquiry's main expert does not obtain any evidence of the practice of comparable social housing managers when making judgments about the TMO. If the inquiry is to make significant findings about the TMO's performance, we submit this should be in the light of what other social housing managers did to develop a fire safety strategy. Turning now to the TMO system for fire risk management and the suitability and competence of Carl Stokes. The TMO accepts it was the responsible person for the purposes of Article 3 of the Regulatory Reform Fire Safety Order 2005 and had responsibility for identifying the general fire precautions for premises under its control. There may well have been other persons who also fulfilled the role of responsible person, but the TMO accepts its own primary responsibility. It is submitted the TMO had a fire safety policy and strategy which was appropriate to its nature and size. This policy and safety strategy have been developed in consultation with LFB and RBKC, at least to an extent. Indeed, Dr. Lane herself considers that the arrangements set out in the fire safety strategy were compliant with Article 9 of the RRO if implemented, including the provisions for review. The backbone of the strategy was to have fire risk assessments produced by a competent fire risk assessor, a plan for raising actions identified, and a tracker to monitor the closing out of such actions. Looking at some other ways in which the TMO managed fire risks, its systems, including the fire risk assessments, were points of discussion in Health and Safety Committee meetings. They were a standing item in its annual health and safety reports and were a point of discussion at the meetings between LFB and the TMO. They were also subject of scrutiny at the RBKC Scrutiny Committee. The fire safety strategy was reviewed on a regular basis, including following significant events such as the introduction of W2, the Adair and Grenfell Tower notices of deficiencies and concerns raised by RBKC, and the TMO made appropriate changes when problems were identified. Dealing now with the question of Carl Stokes' competence to carry out FRAs on behalf of TMO and the way in which he did them. In general terms, the TMO considered him to be a competent fire risk assessor and fire consultant, and there is strong evidence to confirm this was the case. For example, Colin Todd says of his FRAs, the level of detail is, in my experience, well in excess of that normally included in FRAs. The documented FRAs are amongst the most detailed of the many thousands of FRAs I have studied. In my opinion, the level of detail goes well beyond that necessary for the FRA to be regarded as suitable and sufficient. So while the TMO accepts that there are some anomalies and possibly some redundancies in his fire risk assessment, overall, it's submitted the TMO was and was entitled to conclude that he was competent and producing suitable and sufficient risk assessments. And there was never a point reached where it should have concluded that he was not competent and dispensed with his services. Can I deal briefly with how he came first to be TMO's fire risk assessor for Grenfell Tower? So as you know, the Fire Safety Order 2005 heralded a change to approach towards fire safety, wherein the previous regime was replaced with a system mandating a risk-based approach to fire safety by the responsible person. In late 2008, early 2009, the TMO, RBKC and LFEPA entered into discussions about the suitability and sufficiency of the TMO's FRA program, which resulted in a joint decision to procure specialist consultants to undertake FRAs across the TMO stock. The contract was put out to competitive tender, and 4 tenderers submitted bids to the TMO. The company Salvus Consulting Limited was successful and was appointed to carry out the high-risk premises assessment program. Salvus was introduced to the LFB, who approved its approach. Further, LFB accompanied Salvus's assessors on FRA visits to monitor their performance, ensure that agreed standards were being consistently applied. The TMO put the contract for medium and low-risk properties out to tender, and Salvus and a number of other companies applied, with all interviews conducted jointly with RBKC, who had requested to be involved in the process. The TMO interviewed around 6 organisations, and in August 2010, Carl Stokes and Associates was appointed by the TMO and RBKC. And so, as you know, Carl Stokes had previously worked for Salvus and had done the initial risk assessment for Grenfell Tower. In terms of experience, Carl Stokes had been employed in the fire and rescue services for 23 years before carrying out his first fire risk assessment for the TMO, and had engaged in substantial academic and practical training beyond his operational firefighting role. Overall, Colin Todd considers that Carl Stokes' work experience, academic and practical training and experience as a fire risk assessor was more than adequate to equip him for the role of fire risk assessor for Grenfell Tower. In reaching this conclusion, he notes that Carl Stokes had undertaken audits of the common parts of high-rise residential tower blocks and been part of a working group that drafted very well-known and established guidance on fire safety in certain types of housing. So while, of course, the TMO accepts that as responsible person under the RRO, it ought to have kept Carl Stokes' FRAs and ad hoc advice under review, it submits, the TMO says, that it's unreasonable to think that it should have continuously second-guessed his approach in the way that Dr. Lane has suggested. First, for a non-specialist organisation such as the TMO to disregard specialist advice is a dangerous course for which it might rightly be criticised. Second, while there may have been times when it was right to question his approach, such as, for example, when LFEPA expressed their concerns in January 2016, it submitted that TMO did follow up on these concerns and took steps to satisfy itself that he was producing suitable and sufficient risk assessments. The TMO is aware that the inquiry will examine its response to the queries raised by LFEPA in April 2017 in connection with the fire performance of the cladding and what Dr. Lane describes as its shallow response, which she characterises as a quick email exchange, absent of technical fact. The TMO submits that Dr. Lane's view places unrealistic expectations on it. She appears to be saying that the TMO, uniquely among the 2,000 clients whose buildings were clad in unsuitable materials, should have itself been unable to unpick the systemic misconceptions and misrepresentations concerning the suitability of this type of cladding and insulation. So in fact, Carl Stokes did investigate the fire performance of the cladding. He states that he noted on the previous risk assessment, again, I quote, cladding external non-combustible metal fixing signed off by BC, i.e. building control. And he says that he understood that the system and component parts would have been compliant with the requirements of the building regulations and ADB. Thus, when Dr. Lane says in her phase 3 chapter 10 report that LFEPA concerns regarding cladding should have been addressed within the FRO process, it submitted this was done at least to an extent. Although, so we note that there is a significant debate within professional circles, or certainly was a significant debate within professional circles about whether the external wall of a building should indeed form part of a fire risk assessment at all. So now turning to the system the TMO had for dealing with actions identified by its fire risk assessments and notices of deficiency. After an FRA, action points identified were initially put onto the W2 system by Janice Ray or Cyril Morris. Janice Ray was then able to assign FRA actions to departments and individuals within departments for completion. Staff assigned actions would be expected to update the entry on the W2 platform, but only Janice Ray could mark the actions complete or partially complete. So we understand that if when actions were identified and targets set for closing them out, those targets were sometimes missed, it will be a matter of concern to the inquiry, but would submit this, that it's partly a function of the number of historical actions that existed and of the limitation on resources. Of course, the TMO's aim was always to close out actions in time, but the failure to have done so should not be taken to imply or connote a lack of urgency or disregard for safety by the TMO and its staff. So we accept that the picture surrounding the closing out of actions is statistically complex, and it's accepted that the rate at which they were closed out varied quite substantially between 2013 and 2017. However, to give an overall picture, from December 2013 to June 2017, the total number of actions that had been assigned was, according to Dr. Lane, 3,300, and the total number completed was 2,993. The TMO's programme for closing out action was scrutinised at senior levels. For example, the number of actions outstanding was regularly reported to the Health and Safety Committee, and in 2016, this resulted in Robert Black pressing for actions older than 6 months to be completed urgently. At the Health and Safety meeting on the 19th of January 2017, Barbara Matthews also raised a concern over the large number of actions which had been outstanding for over 12 months, emphasising the need to clear them urgently. In fact, she requested that each team with outstanding actions prepare a written report setting out the detail of each action assigned, the steps taken, and when the action would be fully completed. And so the minutes of the Health and Safety Committee meeting on the 16th of March show that this was done. Focusing now on the most recent fire risk assessments for Grenfell Tower by Carl Stokes and the extent to which actions identified there were closed out before the fire. The action plan for the June 2016 FRA indicated there were 47 items requiring action. And by 19th of October 2016, just before an inspection by the LFB, only 22 actions were outstanding. The TMO acknowledges, may say so, the TMO acknowledges that Dr. Lane says that some items were wrongly closed out. And of course, the inquiry will have to assess whether this was correct, and if so, what were its effects. Dr. Lane states that by the night of the fire, of the 7 items that remained open on the tracker, 5 were marked as not fully completed and 2 completed. While of course it will be a matter for the inquiry, of the 5 items not closed out, it is submitted that none was relevant to the causes of the fire, and only one was potentially relevant to the question of mitigation of the fire once it had started. So now deal with notices of deficiency. Following the LFB visit in October 2016, the LFEPA issued a notice of deficiency for Grenfell Tower. The NOD listed actions which, according to the notice, should be taken by the 18th of May 2017 and related to 7 issues, which Dr. Lane summarises in 5 issues. All of the issues were identified as minor deficiencies by the LFEPA. While it is correct that by the time of the fire, the TMO had not resolved all of the issues, all had been given substantial attention. And so one of the issues raised by LFEPA was in relation to self-closers on flat entrance doors. And the TMO fully accepts that the inquiry will subject this particular issue to great scrutiny. In overall terms, the TMO acknowledges that while there was undoubtedly a problem with door closers, it did have visibility of the problem, and a program was underway to retrofit them across the RBKC estate. And so the following history is relevant to that consideration. In March 2011, TMO entered into a contract with Mance Master Door for the renewal of flat entrance doors across its estate, including Grenfell Tower. Between 2011 and 2013, Mance Master Door replaced 106 flat entrance doors to Tenant and flats at Grenfell Tower. It was a condition of the contract that the replacement doors would be FD30S, that is, capable of resisting fire under test conditions for a minimum of 30 minutes and limiting the leakage of smoke to a prescribed extent. Carl Stokes himself was involved in the programme to fit new doors, and he later confirmed to the TMO that so far as he was concerned, the new fire doors met the requirements of the building regulations in terms of fire protection. So the TMO notes the evidence suggesting that almost immediately after the doors were installed, it was observed that some self-closing devices were insecure. There is evidence, in fact, that the problem was brought to the attention of Mance Master Door, who returned to remediate the problem, although it's noted that there's not appears to be any clear evidence to say what steps Mance Master Door took and how many door closers were inoperative. And again, so we accept that the inquiry will look at this particular issue closely. So there's also evidence, the evidence of Seamus Dunley, who was an ESA, an estate services assistant, who is now sadly deceased. The evidence being to the effect that he disconnected a number of door closers at residents' requests. So this is plainly concerning, but it's noted the issue was raised in correspondence between Janice Ray and Siobhan Rumble, both of whom you will hear from in topic 2 of module 3. And it's understood that Seamus Dunley was told to desist. So when in late 2015, the TMO received a notice in respect of Adair Tower, which included recommendations in relation to fire doors, it sought to introduce a borough-wide replacement programme. It also responded to the matters concerning flat doors in the notice of deficiency issued for Grenfell in November 2016. The TMO did not have money in its existing budget to replace the fire doors, and it was necessary to revert, therefore, to RBKC for additional funding. While it's absolutely right that RBKC agreed to funding, it said that the period within which the door closers would be retrofitted would be 5 years, not the 3 years the TMO wanted. The TMO also applied for funding to instigate a programme of periodic inspection and repair after the replacement programme, but this was not agreed to by RBKC. So a test conducted after the fire showed there were serious discrepancies between the fire performance of the doors and the evidence submitted to the testing body. In simplest terms, they didn't have the 30 minutes fire resistance represented by Mance Master Door. And so it's difficult to overstate the seriousness of this misrepresentation. With this in mind, the TMO queries the inquiry's recent decision not to hear oral evidence from witnesses from Mance Master Door. The TMO would submit there's a strong argument for saying that these witnesses should be called to explain the situation and their conduct, just as witnesses from Celotex, Arconic, and Kingspan were asked to explain their own products. Particularly, sir, as after the fire, evidence has emerged of more widespread failures in the performance of fire doors, which led the then Community Secretary, James Brokenshire, to conclude that there is evidence of a broader issue across the fire door market. So turning now to the provisions TMO made for dealing with vulnerable residents. The TMO fully accepts it was necessary to make provisions for the protection of vulnerable persons in a fire scenario through its fire risk management system. It notes the criticisms made in the opening statements by the BSRs and accepts that the inquiry will subject the arrangements it did make and the basis on which they were made to great scrutiny in this module. The TMO invites the inquiry to consider the provisions it did make for vulnerable residents against the background of the stay put policy and its adherence to the LGA guide. These affected and largely determined its policy, including its approach towards personal emergency evacuation plans, or PEEPs. In her report, Dr. Lane assesses and compares the wider guidance documents regarding vulnerable persons and fire risk, opining that the TMO and/or Carl Stokes should, as a minimum, been required to consider the body of guidance, as she puts it, available, and not focus on the LGA guide. She recognises that the LGA guide provides substantially different advice to other guidance, and by applying it, a duty holder would take a different approach towards safeguarding of vulnerable persons. The inquiry will note that the guidance was produced by the LGA, or at least developed by the LGA, following the fire at Lakenhall House in July 2009, and published after wide consultation, including with DCLG and the Chief Fire Officers Association. The LGA guide was substantially written, indeed, by the inquiry's own expert, Colin Todd. Apropos of its adherence to the guide, the TMO is a statutory body whose lawful obligation would be to follow guidance produced by DCLG and LGA. And so further, the LGA guidance postdates all of the other guidance that Dr. Lane refers to, having been produced in 2011. You heard these quotes, I believe, from Mr. Maxwell Scott just before my oral submission, sir, but can I repeat them here? The LGA guide states that while there may be vulnerable persons in blocks of flats, it is usually unrealistic to expect landlords and other responsible persons to plan for this or to have in place special arrangements such as PEEPs. Such plans rely on the presence of staff or others available to assist the person to escape in a fire. Paragraph 19 of the guide says the alternative to a stay put strategy is one that involves simultaneous evacuation, and notes that this requires a means of alerting residents of the need to leave the building. It observes that purpose-built blocks of flats, such as Grenfell Tower, are not normally provided with general fire detection and alarm systems, because experience has shown that most residents do not need to leave their flats when there is a fire elsewhere in the building. Indeed, it says, in some circumstances, they may place themselves at greater risk if they were to do so. The guide also suggests that the risk inherent in the absence of a fire detection alarm system in high-rise blocks is acceptable because it's very rare for there to be an extensive failure of compartmentation. And this is consistent with the absence from approved document B of the requirements for high-rise residential buildings to be fitted with the means of communicating with all occupants simultaneously in order to facilitate a total evacuation. Indeed, the stay put policy had been in place for many years at Grenfell Tower and was extensively communicated to the residents of the tower. It was well known to LFB and LFEPA, and it was never suggested by either that TMO should implement a full evacuation policy, either in place or in addition to a stay put policy. And the stay put policy remains to date one approved for similar high-rise blocks by the National Fire Chiefs Council. So in her report, Dr. Lane sets out 3 scenarios in which vulnerable residents may be affected where a fire occurs in a block with a stay put strategy. These are where the fire occurs in the resident's flat, where it occurs in a neighbouring flat, or where the fire has spread to the common parts. She says that the duty holder should make provision for 3 corresponding scenarios. The occupants of the flat of fire origin make their escape, occupants in any adjacent flats make their escape, and all other occupants in the building leave should a simultaneous evacuation strategy become necessary. So the TMO accepts that you will no doubt assess whether, in the light of the stay put policy and adherence to the LGA guide, the TMO should have prepared for all of these scenarios, but it's respectfully submitted that when making provisions for vulnerable residents, the TMO is entitled, if indeed not bound, to work on the basis that compartmentation would not fail and all residents would stay put, save for those in the flat of fire origin. So may I deal now lastly with lifts, and in particular the inability of LFB to take control of the lifts. So in your phase 1 report, you said when the firefighters attended the fire at Grenfell Tower, they're unable to operate the mechanism that should have allowed them to take control of the lifts. Why that was so is not yet known, but it meant that they were unable to make use of the lifts in carrying out firefighting and search and rescue operations. It also meant that occupants of the tower were able to make use of the lifts and trying to escape, in some cases with fatal consequences. The ability of fire and rescue services to take control of firefighting or fire lifts in a high-rise building is often key to successful operations. And so may we echo your intention to examine this serious issue with the greatest intensity. So following the phase 1 report, you, the inquiry, obtained evidence from various parties associated with the replacement of the lifts at Grenfell Tower in 2002 to 2005, and the maintenance of them following the refurbishment, including the maintenance of the fire control switch. As the inquiry is aware, between 2003 and 2006, the lifts at Grenfell Tower were replaced by Apex Lift and Escalator Engineers Limited, pursuant to a specification by Butler and Young Consultants Limited. Butler and Young did not specify that the replacement lift should not be firefighting lift, something the inquiry's lift expert, Roger Hawkins, criticises. In the event, fully compliant firefighting lifts were not installed. At a later stage, Carl Stokes represented in his FRAs that the lifts were firefighting lifts, which was not correct. In fact, Janice Ray and Robert Cahalan were both aware that they were not firefighting lifts, despite Carl Stokes' representations. And so they, in particular, were not in fact misled. Janice Ray always understood that the lifts would not be used to evacuate residents in the event of fire, as the strategy for Grenfell Tower was stay put. Turning to the maintenance of the lifts, Roger Hawkins states that although there were some failures overall, the lifts appear to have been maintained to an appropriate standard and were generally in compliance with the relevant standards and industry practice. He did not think it likely that a maintenance failure caused the problems with the fire control switch. Following their installation, the lifts at Grenfell Tower fell under a maintenance contract overseen by a contract manager within the building services team. The lift maintenance contractor was Apex Lift Limited, and the contract included monthly inspections. So you're going to hear witnesses from PEDAs, I think Paul and Dunwoody, who will say that planned maintenance visits were carried out on a monthly basis in accordance with the maintenance schedule. The witness from PEDAs will say that engineers would follow a standard checklist when conducting a service. As well as ensuring that items listed on the schedule were in good working order, the engineers would ensure that the fire control switch was in good and proper working order by inserting the correct key, which at Grenfell Tower is an express drop key. He says that they would insert the key into the switch, activate the system, and check the lift would immediately move to the ground floor before opening the doors. They would then check that the lift operated in the desired manner, i.e. move to the chosen floor before the doors would open when the correct buttons were pressed. So we note the criticisms of Dr. Lane, and of course we accept, the TMO accepts that records of checks would have been desirable, of course, and that the checking of the fire switch could have been a specific item on the ESA's checklist. But so we say the absence of such records is not to be equated with the checks not having occurred. So in conclusion, again, to repeat what I said at the beginning, the TMO acknowledges the immense tragedy of the Grenfell Tower fire, and nothing that I've said is intended to diminish or detract from that tragedy. So the TMO is not saying that it got everything right regarding the refurbishment, or that its fire strategy and the way that it was applied was not capable of criticism. And the TMO is certainly not seeking to do this. However, we do urge the inquiry to exercise, to judge the TMO, we do urge the inquiry to ensure that the TMO and its staff are judged by an appropriate standard, and not one which was higher than was applied elsewhere at the relevant time. So you know that these submissions have been drafted in order to set out the general position of the TMO in advance of the important evidence that will be heard in Module 3 of Phase 2 of this inquiry. Of course, they've been prepared with the statements in mind, but without hearing that evidence. And if anything said here is subject to review, once that evidence has been heard. And finally, sir, may the TMO and all the witnesses to give evidence in Module 3 continue to offer their full support to the inquiry in fulfilling its important statutory functions.
Well, thank you very much indeed, Mr. Agros. That is extremely helpful. We have 3 more oral opening statements to hear, but they've all been programmed in for tomorrow's hearing, and I think it would not be reasonably practicable to invite any of those who we're going to hear later to make their statements this afternoon. So we are going to call a halt at that stage. We'll resume at 10 o'clock tomorrow morning, when, as I say, we'll hear some further opening statements. Good. Thank you all very much.
Thank you, sir. Mm-hmm.